The nature of international law. International law, often termed the law of nations, is a distinct and complex legal system that regulates the relationships among its principal subjects, which are nation-states alongside international organizations and, in certain instances, individuals. The very existence of international law is rooted in the fundamental necessity of order for a stable existence, serving as the binding element for a community that adheres to recognized values and standards. As a system of rules and principles, international law covers nearly every aspect of interstate activity, including conflict, commerce, telecommunications, environmental protection, human rights, and the use of force. Its nature is multifaceted, reflecting both permissive aspects, allowing subjects to establish their own legal relations, and coercive elements, punishing those who infringe its regulations. Fundamentally, modern international law operates as the vital mechanism without which an increasingly interdependent world could not function. A defining characteristic of international law is its profound difference from domestic or municipal legal systems. Domestic law is generally hierarchical, with authority centralized in institutions such as a legislature, judiciary, and executive, possessing the practical competence to compel obedience and enforce regulations. International law, by contrast, functions as a horizontal system, encompassing over 190 independent states that are legally equal in theory, recognizing no single authority above them. The international system is characterized by an absence of centralized governance, resulting in a decentralized and non-hierarchical lawmaking process. This structural difference leads to the primary criticisms leveled against its validity as true law. Critics note that the international legal system lacks a global legislature, as resolutions from the UN General Assembly are generally not legally binding. It lacks a universal system of compulsory courts. The International Court of Justice can only hear cases when both parties consent, and it lacks the power to enforce its decisions reliably. Most importantly, it lacks a true executive or governing entity capable of ensuring that violators are punished. However, this comparison often proves misleading. International law is not simply an adjunct of national legal orders, but a separate system altogether. While individuals within a state obey laws created by specific institutions, international law is unique because states themselves both create the law and decide whether to obey or disobey it. Instead of imposing control through command and compulsion, international law aims to facilitate the interaction of legal equals. It functions as a law of coordination rather than subordination. When international lawyers refer to a state as sovereign, they primarily mean that it is independent, not subject to external control. But this independence does not place it above the constraints of international law. The fundamental question concerning the nature of international law is its juridical basis. Why do states feel obliged to obey these rules? Several major theoretical schools have attempted to answer this question, reflecting a tension between political reality and legal ideal. The 19th century command theory, championed by John Austin, dismissed international law entirely. Austin defined positive law as commands issued by a sovereign backed by sanctions. Since international law lacked a superior sovereign and institutionalized sanctions, Austin categorized it as mere positive morality. This theory has since been criticized for unduly emphasizing coercion and inaccurately describing even domestic legal systems. The traditionally dominant approach is the consensual or positivist theory, which asserts that the binding nature of international law flows directly from the consent of states. Under this view, international law is man-made, derived from the actual practice and agreements of states, and exists solely because states will it to be so. However, pure positivism faces significant challenges. It struggles to explain why newly independent states are bound by pre-existing customary rules they never consented to. Crucially, it cannot logically explain why a state cannot unilaterally withdraw its consent once given, as the rule that agreements must be kept, pacta sunt servanda, upon which all treaty law rests, cannot itself be based upon consent. In contrast, natural law theories suggest that rules of law are derived from inherent reason, morality, or justice, providing a higher standard to which positive rules must adhere. Historically significant, natural law principles continue to resonate today through concepts like equity, human rights protections, and jus cogens. Jus cogens rules, such as the prohibition of aggression, genocide, and slavery, are recognized as norms so fundamental to the international legal order that no state may derogate from them, even by mutual agreement. These norms represent a body of higher law that challenges the absolute freedom suggested by positivism. A more practical perspective suggests that the juridical origin lies in necessity. International law is binding because it is essential for the common good and required to ensure a stable and orderly international society. This pragmatic view recognizes that states operate in an interdependent world and require a regulatory framework to play the game of world affairs, which international law provides. Despite the appearance of weakness stemming from the decentralized nature of international law, the great majority of its rules are followed consistently every day. Non-compliance, such as armed attacks, is rare but highly publicized, creating the misconception that the system is failing. The effectiveness of international law rests on several factors beyond mere enforcement. States comply because international law is based on common self-interest and necessity, providing stable and predictable principles for conducting international relations and commerce. Compliance is also motivated by the desire to maintain a good reputation, fear of retaliatory measures, and the principles of reciprocity. While international law is certainly challenged when states perceive their vital interests to be threatened, it often still serves to modify or soften illegal conduct, bringing it closer to the legal norm, even if the violation is not prevented entirely. The existence of the law means that states invariably seek legal justification for their actions or deny responsibility rather than claiming they are above the law. In conclusion, international law is a dynamic legal system characterized by its horizontal structure and reliance on the consent and cooperation of sovereign equals. Although constantly navigating tensions arising from the assertion of state sovereignty and the persistent challenge regarding enforcement, its pervasive influence and daily observance underscore its nature not as a primitive system, but as an indispensable regulatory framework for global society.